Hello and welcome to the editorial discussion of the Hindu. Today we shall be discussing the newspaper of the 19th of February. So coming to the first article, the contractual functionary. This is a very important article because this is a social issue which has been discussed, and for the general studies paper 1 social issues this becomes a relevant topic. Also this can be used in your essays. It also has some ethical undertones to it. So the article is an important one. Now coming to the context. The context here is that last month there was the death of a person named Mr. Kishan Lal, who was aged 37 years. He was a sanitary worker and he died inside an underground drain in the nation's capital, in the Wazirabad area of New Delhi. So that is what is the context. Now this highlights several issues. The first issue is with regards to the term contract worker itself. Now here you need to understand that before 1991, a contract worker was a term that was used for any employee who was employed in the private sector. This was largely because the government job is what was considered permanent and private sector was considered temporary. But now this is something that is not the case. The meaning and the scope of this word contract worker has expanded largely. This is because after 1991, there has been LPG reforms and even the government now is hiring several workers as contract workers. So this is something that has been highlighted by the author, that the term contract worker is now used for a large degree of workforce in India, and this is what is a cause of concern. Another thing which has been highlighted here is the lack of regulation which contract workers face. This is largely because there is a jungle of norms and procedures which is there in the country. We also do not know the share of the permanent staff that is there, that is working as contract workers. So this is another cause of concern, that even adequate data is something that is missing on the number of workers who are working as contract workers. So obviously it is difficult to regulate them, and that is what has been highlighted in the article. The third issue which has been highlighted, which is the most important issue here, is the relation between caste and sanitary work. Now here the author highlights that despite the fact that this is being something that is being ignored time and again by the media and other intelligentsia of India, the issue is that till today the sanitary work is something that is given to a particular caste, which is the SC category. The SC caste is doing this work even today, and this is decades after independence, and this is something that has still not changed. So this shows that how caste even today continues to be a discriminatory factor in India, and caste related employment is still continuing in India, and this is something that is unacceptable. So that is what has been highlighted. Another issue is the policy of privatization. Now, as I mentioned before also, that it was in 1991 that the policy of privatization is what the government adopted. This was, however, done without an effort to work out the details for different sectors and different departments by the government. And what is happening here is that in the name of efficiency, which privatization ensures, what is happening is that the justice and equality of people is something that is suffering. Because of this privatization, what is happening is that a large number of workers are coming as contract workers, and there are no regulation, no safeguards for them. So there is no justice for these workers, and that is what has been highlighted here. Another issue which has been highlighted is the role of bureaucracy and politicians. Now what happens is that if LPG reforms are what were introduced, what is important is that even if privatization takes place, the bureaucracy and politicians become strong because they have to do a regulatory role. But what is happening here is that both the bureaucracy as well as politicians are being criticized for not fulfilling their duty. They are complicit in regulating the contract workers, and as a result of which, what is happening is that private companies are exploiting the contractual workers, and as a result of which this kind of tragedies is what is happening. So that is one point which has been highlighted. Another thing which has been asked for in this particular article is a review of the contractual system entirely in India. Now here the author highlights that in areas of welfare, for example in education department, in health department, in sanitation department, everywhere we are seeing that there is contractual workers who are working, and because of this the dedication of the workers is something that is not there, because these workers are not being paid optimally. So as a result of which they are not performing efficiently. For instance, even in the education sector, a large number of teachers that the government is hiring in government schools are on contract, and compared to the permanent staff there, they are being paid very less. Now the government gives an explanation that just because of the fact that these teachers are not permanent, they will work more. But this theory is clearly a failure. That is not happening. The teachers here do not have a motivation to work in schools, and what is suffering is the education of people. Another thing, in health departments, similar things are being seen, that because employees are contractual, the facilities in health in government hospitals is something that is deteriorating. That is what has been highlighted by the author, and he has called for a review of this entire system. Another issue which has been highlighted is the exploitation which is taking place. The exploitation is with regards to low wages which these workers are given. Also, there is no protection offered to them. They do not have a job security. Also, the service conditions are poor. For instance, in case of the sanitary worker, there was no safety gear that he was wearing. In fact, he has died of asphyxiation, which is shameful for India. So this is what has been highlighted in this particular article. These points become very much relevant whenever we are discussing a particular social issue, especially the relation between sanitary work and caste is what is the key crux of this particular article, which makes it very, very important. So that is the relevance. Coming to the next article, India's options after Pulwama. Now the context here is the deadly terror attack against a CRPF envoy in South Kashmir's Pulwama district, which was orchestrated by the Jaish-e-Mohammed suicide bomber. Now, some issues is what has been talked about in this particular article, which are important. The first issue is with regards to Pakistan's denial. Now, here the author says that it is obvious that Pakistan's Prime Minister is denying this attack, and it is time again that this is happening from Pakistan's side. There is no secret that the Jaish-e-Mohammed leaders are roaming freely in Pakistan. And indeed, if this kind of an attitude is there, then this is intolerable to India, and this can never harbor peace between the two countries. Not only this, this is also a threat to Pakistan itself, because if Pakistan is breeding terrorism on its soil, then someday it is going to fire back to Pakistan itself. Further, even in the Pathankot attacks, there also Pakistan was reluctant, and it continues to be reluctant in giving information and support to the Indian agencies. So that is something that has been highlighted in this particular article. The second issue which has been highlighted is with regards to the raging insurgency in Kashmir. Now this is the most important analysis of this particular article. Here you need to understand that this attack is what was carried out by a young boy named Adil Ahmed Dar. He was aged 22 years and he was a local Kashmiri boy. So the issue here is that if a local Kashmiri has done this attack, then it clearly proves that there is insurgency in Kashmir. And this is the biggest concern for India. And what is being said here is that the focus should not only be on Pakistan, but on Kashmir itself, because the problem is something that is within India. So this needs to be tackled as well. Another issue which has been highlighted is with regards to the failure of New Delhi's Kashmir policy. Now, obviously, there is a failure of Kashmir policy in India. This is primarily because some data is what is insinuating towards this. For instance, in the year 2013, some data is what is given in the article, that in the year 2013, there were 6 people who joined militancy in Kashmir. And by the year 2018, this number has risen to 200. So the number indeed shows that there is a rise in insurgency, and there is a failure of New Delhi's Kashmir policy. Also, ceasefire violations is what has increased 5 times since 2014. Then terrorist-related violence is what has spiked drastically in Kashmir. So all of this is definitely showing that in the past 4 years, the policy that has been used by the government is a complete failure. And this is largely because the 4-year policy has been an aggressive policy. And this is what has happened because of this aggressive policy is that the opinion of people in Kashmir has largely gone against India. And this is what is the basic problem in Kashmir. That is what has been highlighted here. Another issue which has been highlighted is the intelligence failure. Now here the editorial discusses that this was a plan that was carried out by a local, and he was on the radar of the local police. This was a plan that was carried out on the national highway of a state which is already disturbed. So this clearly shows that there is an intelligence lapse, there is an intelligence failure which needs to be heightened and which needs to be mounted. So obviously there is a lesson for India to learn from this particular attack. Another issue which has been highlighted here is with regards to India's options. Now these are something that is important. Now here the author says the options that India can use should be first and foremost credible, they should be prompt, and they should be visible. So what can India do? First and foremost is that India is trying some soft tactics with regards to the Indus Water Treaty and the most favored nation. But obviously this Indus Water Treaty action in Indus Water Treaty is not something that is feasible because India cannot control it. India cannot stop the Indus waters. And also with regards to the most favored nation, this action taking away the most favored nation status from Pakistan is of not much avail because Pakistan already has very less of trade with India. So what are some other options which India can explore? The other options here probably would be isolating Pakistan, which India is doing, but that again is something that is facing roadblocks because of China's closeness to Pakistan. Russia is warming up with Pakistan and America is withdrawing from Afghanistan. We had discussed this yesterday also. So the third option that India has is the military option. Here again the author says that if India goes in for a surgical strike or an air strike, what's going to happen is that we are going to face some retaliation from Pakistan, and this again is not in the interest of India. So this is one challenge which the author has highlighted. Further, he talks about some covert operations which can be invisible, hidden operations. We had discussed yesterday also, but this might not assuage the anger that the country is experiencing at this particular point of time. So these are some options which the author has explored. Next, some opinion is what is given in the editorial, and this is what we have to take from the editorial for our answers and for our opinion. The first opinion is that there is a need for a great deal of political sophistication. These are some key words which we can use in our answers. Another thing is that the author is talking about is some back channel reaching out. This has time and again been highlighted by experts, and whenever you give your suggestion on Kashmir, you have to highlight that some back channel diplomacy is what is required. Another thing that the author has talked about is some comprehensive political vision to get Kashmir back on track. Curbing insurgency in Kashmir and a new policy towards Kashmir is the need of the hour. Another opinion which the author has given is that India could probably hold discreet talks with China to curb Pakistan. But again, this is something that is a long-term process. This will require patience on the side of India. So that is the entire analysis of this particular article. Pulwama episode will be a very, very important one for the mains coming up this year. Now coming to the next article, not without an explanation. Now this is not a very important article, but I have basically included this article because it is a rare one. So few points from this article is something that we can use, but otherwise I'm not expecting this article to as such come as a question in UPSC. Coming to the context first, the context here is with regards to the rash of recusals which are made by the judges of Supreme Court in the case challenging the appointment of M. Nageshwara Rao as the interim director of CBI. Now what does this mean is that in this particular case, what we are seeing is that time and again judges are withdrawing from this particular case. They are excusing themselves from this case, and this case is further being passed on to newer judges. First and foremost, the Chief Justice of India, Mr. Ranjan Gogoi, Justice Ranjan Gogoi himself withdrew from this case. He said that he is withdrawing from this case because he was the part of the selection committee itself. Next, it was Justice A.K. Sikri who further withdrew, saying that he was part of the panel that removed the previous CBI director, Mr. Alok Verma. And then it was Justice N.V. Ramana who for personal reasons again stepped back from this particular case. It is not only this one case which is mentioned here. Some other examples is also what is given, which I have highlighted here. So you can read these other examples. Now, what are the issues that are involved? The first and foremost issue is with regards to the oath of the judges. Now, the judges take an oath that they will act without fear or favor and affection or ill will. So, it is under this oath that often judges say that because they might have some affection for a particular party or some ill will for a particular party, in that case, they are making it a ground for recusing themselves from these cases. But the author here is saying that this is not justified without a writing. Because what is being done is that the judges are simply giving an oral statement of their recusal and are not recording their reasons. So that is something that is being highlighted by the author, that if it is the oath of the judges, then also this calls for a written explanation by the judges. Another issue which has been highlighted is with regards to cherry picking bench of choice. Now what is happening is that because so many judges are recusing themselves, often this kind of tactic is what is adopted for cherry picking benches, and this is something that is not in the interest of impartial justice, which the judiciary of India upholds. So that is something that is important. Another issue which has been highlighted is with regards to lack of definite rules. Now here the author says that unlike many other countries, in India there is no definite rules which are describing that how a judge can make a recusal, whether a judge should be allowed to make a recusal or not. So there is a lot of non-explained area. There's a lot of gray zone over here, which is causing a lot of controversy. So some definite rules is what should be framed in this regard. So that is something that has been highlighted. Another issue is with regards to judges deciding for himself. Now, in the absence of laws, what is happening is that a judge is deciding himself whether or not he should hear a particular case. So this is something that is surmounting to some impartiality by the judges, because how can a judge decide for himself? So that is something that is important here. Another issue is with regards to the mistaken case of recusal. Now here the author is saying that this, if a case in which a recusal is being made mistakenly, then what is happening is that this is a destruction to the rule of law, and it is being used as a tool to maneuver justice. And this is resulting in, as we previously also discussed, in cherry picking benches of choice. So, and also this is being misused by the government to select particular judges or to favor particular judges. Another issue which has been highlighted is with regards to difficult and unpleasant tasks. Now here the editorial is discussing that some cases are difficult. For example, the Ayodhya judgment is a difficult case, or for that matter, a case might come against the government, which is a difficult case. So even this difficult task and unpleasant task is something that is the constitutional duty of a judge. And this option of recusing themselves often causes judges to remove themselves from controversial judgments, and this results in few judges being targeted. So this is something that is an unhealthy precedence that is being set in judiciary, and this is something that should be done away with. So that is the entire gist of this particular article. Not a very important one, but you should have some idea about this. That is going to be the relevance. Coming to the next article, discord in Puducherry. Now this is a small article, but I picked it up because we discussed a similar article yesterday also. The context here is with regards to the conflict between the Puducherry Chief Minister, Mr. V. Narayanaswamy, and the Lieutenant Governor in Puducherry, that is Mrs. Kiran Bedi. Now the issues are, first and foremost, there are a lot of differences which are coming between the Chief Minister and the Lieutenant Governor. In fact, it happened to the point that the Chief Minister sat on a protest for 6 days before he met the Lieutenant Governor. So these kind of differences and these kind of protests for the last 2 years is something that is not good for the Union Territory, and that is the first aspect here. The second issue is with regards to the political structure of the UT. Now here you have to understand that the administrator in a Union Territory is the nominee of the President. The administrator is the Lieutenant Governor, and here in a UT, the administrator enjoys some superior powers to the Chief Minister and the Council of Ministers, and this is something that is leading to the conflict. The Chief Minister and the Council of Ministers are elected by the people, so they should indeed have the supremacy over the administrator, but this is what is not happening in these Union Territories, for that matter Puducherry or even in Delhi, and that is what is the cause of conflict. Another thing that becomes important here is the proactive role of the Lieutenant Governor. Now what is being seen is that whenever the Lieutenant Governor is a proactive one, conflicts are on the rise. And this is something that is happening in case of Puducherry also. A harmony between the Chief Minister and the LG is something that is much required for smooth functioning of administration in Union Territories, and this is clearly not happening here. Another thing which is very important is the Section 44 of Union Territory Act of 1963. This is the legal aspect of this particular issue. Here the Administration Act, as per this particular act, it is written that the administration acts on the aid and advice of the Council of Ministers. So the administrator here is going to be the Lieutenant Governor, and he is bound to act on the aid and advice of the Council of Ministers as per this particular act. And if there is any difference of opinion, then that difference of opinion has to go to the President. But till the time the President is not going to decide on that particular difference of opinion, the opinion of the LG is what is going to prevail as per this particular act. So this is what is the legal aspect, and you should be aware of that. Now the issue here is, the important analysis which has been given is with regards to the Supreme Court ruling in the case of Delhi. This we had discussed yesterday also, that in the year 2018, Supreme Court gave a ruling where the Supreme Court said that the LG should act on the advice of the Chief Minister and the Council of Ministers, and the Lieutenant Governor should show some restraint. So here the editorial is discussing that if this was the case, if this was the judgment that was given in case of Delhi, this judgment should also be extended to Puducherry, because Puducherry has a longer history or longer record of elected government. So this is an analysis here, and this should also be our final opinion, because these kind of questions can emerge whether in the case of Delhi or in the case of Puducherry, that wherever it is the people's representatives who are giving a particular decision, then that decision should be upheld as compared to the administrator, because this is a democracy and people are the sovereign. So that is the mindset, that is the opinion that even we should have for these kind of articles. Now that's all for today's discussion. I thank you all for watching this video.